Hi, and thanks everyone for joining the Talking Animals Law and Philosophy series. My name is Raphael Fazil. I am the co-director of the Cambridge Centre for Animal Rights Law. This is the third event in the Easter term, and we've got two more events coming after this. So for anyone who's joining us for the first time, just going to outline briefly how these events work. So after my introduction, we will have a presentation by our speaker that will last somewhere between 30 and 45 minutes, and we'll then have another usually 40 or so minutes for Q&A. We have adopted a webinar format for these events. So the way for you to ask your questions or make your comments is to use the Q&A function at the bottom of your Zoom app. It has a little question mark on it. So you can just pop your questions and comments in there, and you can sort of respond to one another's comments, I think, and upvote comments as well. And once we reach the Q&A part, I will then go through those comments and remarks and questions that are in there and feed them to our speaker. So you're all warmly encouraged to participate that way. We are recording this event, so if you need to leave early or if you want to share this with a friend later on, you can do so. It will be uploaded to our YouTube channel and website in a couple of days' time. Now, I think that's all as far as the sort of housekeeping is concerned. And it is now my great pleasure to introduce our wonderful speaker today, and that's Justin Marceau. Justin Marceau is a professor of law, the Brooks Institute Faculty Research Scholar of Animal Law and Policy, and the Faculty Director of the Animal Law Program at Sturm College of Law at the University of Denver. He co-founded and helps direct a first-of-its-kind law clinic, which is called the Animal Activist Legal Defense Project, and they really do terrific work, so do check it out. Justin is the author of more than 40 academic articles and essays, as well as 2 textbooks. His first book, called Beyond Cages, was published by Cambridge University Press in 2019 and is an extended critique of carceral animal law, and really a terrific book, so I really warmly recommend it to everyone. And his most recent book, another terrific book, is called Truth and Transparency. It was published by CUP 2 years ago, and it was co-authored with Alan Chen, and it was awarded the Tankard Prize. Justin's presentation today is entitled Optimism and Animal Rights Law, Looking at Unlikely Sources of Legal Momentum for Animal Rights. Justin, we're really pleased to have you. The floor is yours.
Oh, thank you. Well, my first act of optimism is getting myself unmuted. My second will be the hope that I will keep it under 45 minutes. Raphael may not know, but I was teaching a first-year law class a couple of terms ago, and about midway through the term, a student came up after class and said, "You know that the class ends at 10:15, not 10:30." And I said, "Oh, we got to fit a little extra in." So, Raphael, don't be shy about cutting me off. I've tried to get this close, but my mind often goes in different tangents. So, thank you for the nice introduction, and thank you for having me. I really want to note that this project has already benefited a great deal from version of this project from the Cambridge Center's workshops and that sort of thing. It's a great benefit to our field to have this center at Cambridge, and I just want to sincerely and really earnestly thank Raphael and Sean for doing this. I think that the folks who are directing these kind of institutes across the globe right now have done a service for the field that it's really hard to measure. And I'm old enough to know that, a decade or so ago, it didn't exist. And the work that the folks do to put this on seems small. It takes a lot of time, and it's largely uncompensated. It's not as though each additional event they plan, they're getting more money. So thank you both very, very much for doing this, and just for the ability to exchange ideas in this field. So today I have offered a talk, or proposed to talk about optimism in the field. And I did that deliberately because I'm generally a quite cynical person. And as you'll see, even today, a fair amount of cynicism sort of slipped into my presentation. I was trying to pull some out earlier this morning as I was getting ready, but it has seeped in. But there's a lot of things, I think, in our movement globally and for me nationally in the US that are a source of concern, a source of pessimism. Just within the last month, maybe just over a month at this point, the New York Times ran a story, maybe some of you saw. It was called Meat is Back. And within that story, there was a quote from a consumer pollster who said, quote, "The days of demonizing meat are done." Meat consumption, according to this article, was up nationally by over 10%. And we were seeing the number of people reporting that they were trying to cut back at the lowest level in many, many years. So I'm not naive. I think that there are a lot of reasons to be feeling disappointed, feeling frustrated, but hopefully not feeling disillusioned. And so I am going to offer some thoughts that are in the vein of optimism. I'm going to frame the optimism through a couple of research projects that I'm working on, and I'll acknowledge up front so I don't have to keep repeating their names. I'm working on a book with Janice Nadler and David Dana, both at Northwestern University. And I will, if they have been the lead on one of the studies, I will acknowledge that. But they're all studies that all of us have worked on, but it's a book that we're working on and for CUP. So Janice Nadler and David Dana are my co-collaborators on a lot of the things I'm presenting. So in terms of the possibility of progress, I'm going to talk about two general areas of research that we've been doing. One is the relationship between incremental, or some would say welfarist reforms and animal rights. And the second is something that's grown out of my work in the clinic that Raphael mentioned, and what we've called voluntary prosecution. I think both of these have possibilities for animal rights, and I'm going to talk about those. But before I do, I want to, and here is some of the cynicism creeping in, but I want to spend several minutes talking about these glimmers of hope surrounding litigation and animal rights more generally. I do see room for optimism, and I will share about my research on that. But there is something of, when it comes to animal rights, thick rights, as Raphael would say, sort of thick rights in the U.S. litigation. And this is somewhat a U.S. point because that's where I've studied this. There's a bit of an elephant in the room. And the elephant in the room, you might say, is Happy the Elephant, or more generally, litigation work pursuing personhood. For about 40 years, starting in the 1980s, Stephen Wise, of course, was writing about, doing talks about, and eventually litigating animal rights in court. And as time passes, I will say I am increasingly convinced that Steve really was a visionary and somebody whose work as a whole really is greater than each of its parts, right? That he put together this body. It's very impressive. And I've had the occasion to do that over the last year and some other research. And I just want to acknowledge that. And of course, it's easy to be nostalgic when one of the giants in your field passes recently. And so I'm not trying to overdo it. But I do think that Steve's work helped shape a lot of my own thinking. But then the question naturally becomes, and it's one that I ask myself a lot, if the Non-Human Rights Project and similar work is so meaningful, then is that where we should be focusing all, or at least a significant plurality or most of our litigation resources? Again, I'm not talking about theoretical projects. I'm talking about sort of boots on the ground litigation efforts. Where should animal lawyers or advocates who are working with lawyers be devoting resources? And if Steve's work was so good, should we be doing more of it? And again, in full disclosure, again, I don't like to give lots of disclosures and too much legwork, but I am on the board of the Non-Human Rights Project presently. I'm not going to say anything that is critical, but I do want to complicate a couple of views that I think are associated with them, although I'm not associating them with anyone in particular there. So in particular, I want to talk a little bit about the idea of winning by losing. And I want to be very precise here. I'm not suggesting that personhood cases cannot or will not ever win at the level of the highest court in a jurisdiction. I think it's possible. I think it's certainly possible, we've already seen it, that we will get dissents. I simply don't know how long it will take to win outright in a court of the highest jurisdiction, certainly in the US, in a way that's going to have support for and be enforced in the ways that people, I think, who believe in animal rights trust will flow from these decisions. It might be a year. I don't think so. I don't think it will be 2 years. I don't think it will be in this decade. Reasonable people might disagree, but I don't think we're going to see a massive personhood decision in most Western democracies in the next decade. So then, if you stay with me and you assume that I'm right, that there's not an imminent, large-scale victory for personhood in the foreseeable future, then there's a question about the losses. And in particular, a question about whether we should just keep doing the versions of the same litigation, like a 50 state strategy. How good is that? How likely is that to prevail for animals to present opportunities for winning? And there is a theory, right? This is quite famous in the US literature, and it started to bleed into animal rights literature more generally from the legal literature. The theory is winning by losing, right? The idea is that losses provide a basis for creating momentum towards a win. And there's different ways that could happen. I won't go into all of them, but it could happen that the courts start to feel bad and regret their decisions. More often, it's explained in terms of mobilizing the public, creating sharp contrasts that the public can then use to leverage the position. But the simple way to understand it is that you're losing forward. You lose a case or you lose a set of cases, and that's actually good, right? It's kind of the metaphorical loss of a battle to win the war, right? You will eventually galvanize support through your losses, and that will help shift public opinion. There's some historical precedent for this in the US. It's complicated, and I think that some of what I've read tends to oversimplify it. So I risk doing that here in 20 seconds in a talk. But I will say that there are scholars who have said that some of the NAACP civil rights era cases in the US were based upon this idea that they knew they would lose and they would keep bringing those cases because it would heighten the contradiction. It would show quite precisely what segregation law looked like. When you lose this case that argues for desegregation, you can see more clearly what that looks like. And there are people who have said that that is part of what the strategy was. I think even more clear is marriage equality fights in the US. Some of the early litigation around marriage equality in the US, advocates specifically called the cases antics and acknowledged very candidly they didn't think they had a chance in hell of winning. They didn't think that, right? And so there were these precedents. And perhaps not surprisingly, given the relative success of those movements that I have just really quite flattened and simplified in ways that I'm happy to talk more about later, there is a sense in which, of course, the animal rights movement want to borrow from this and benefit. And I can tell you from conversations I had with Steve more than 6 years ago that he was a student of this literature. He was fond of thinking about progress in this way, and even noted to me a book that we had both read by Christopher Schmidt, talking about the reality that sometimes Thurgood Marshall seemed to have just been hunting for a dissent, that was going to be enough. But for my part, again, I don't have any crystal balls. I don't have a future-telling device. But I wonder how that plays out when it comes to animals, right? Will it be the case that the winning by losing is going to help us? And I want to make a couple of just very simple points here that are probably obvious, but I don't think that we treat them as obvious in the animal rights field, or we haven't thought about them much. First, and most obvious, is it's just too simplistic to assume that every time we lose in court or at the election box, that we have therein done something that we can declare as a win. Every loss is not a win. There's lots of social factors that go into making a loss a possible win. And so it's not the case that just losing by itself is good. And in fact, it could be quite bad. There's a saying that if you shoot for the king, you better not miss. And I could give you examples. There are lots of them outside of the animal context where this becomes clear. But I'll give one that is to protect the advocates from any shame, and I'm not trying to point fingers. I'll anonymize this and sort of change the issue slightly. But imagine the following ballot campaign, right? Imagine that in the city you live in, there is something equivalent to a SeaWorld, some sort of large, very unfriendly aquarium housing a lot of animals. And imagine further that it's quite unpopular. No one seems to really care about it much. It's falling a bit into disrepair. It's not very, very popular. And so a local advocacy group or a national advocacy group say, well, look, this looks like a winning issue. We're looking for wins. And so as we look for wins, let's target this because we might be able to shut this place down through a local initiative or a statewide initiative to end this, right? We could achieve rights. And so they start a campaign to do just that. And it seems like who could fault them because public opinion isn't very favorable. Their initial polls show people don't really care. So this seems like a possibility. But it turns out that this SeaWorld type entity or large aquarium, maybe it has a national parent company, or maybe it has chains in other localities or other states that are more successful, or even other countries. It's a global market at this point. And so when the ballot initiative comes up, what happens is that something of a sleeping giant is kicked. And they do, in fact, kick into overdrive. And in the process, they spend hundreds of thousands, if not millions of dollars, flooding the community with advertising, yard signs, public meetings, with all kinds of misinformation about what animals do and don't like, what kind of conservation is and isn't happening, what's good for animals, the job loss, the economic harm, and so on and so on. It turns out that after a 9-month campaign, in a relatively narrow defeat, the aquarium wins, and the animal rights activists say, shoot. But they say, but don't worry, we actually won because we got this issue out there. And that's the question, right? Is just getting the issue out there, is getting people talking about it enough? Or is there a risk that in having had this entity spend all this money, people are now more locked in? Would it be harder to run a ballot initiative to shut down the SeaWorld today than it was at the time of the election? Are there forces more aligned in support of them? Have they made alliances with hunters organizations? Have they made alliances with the zoo? All of these things could happen from something that seems straightforward. It seemed like a relatively unpopular, relatively aging animal abuse practice. And yet, right, the loss could galvanize support for them. Again, the point here is that winning by losing isn't automatic. We don't simply win when we lose. So then what should we care about? Well, I think a lot of animal advocates would say, don't worry, because what we're doing is we're trying to create a media narrative. And so a successful case at least is going to have a very skilled public relations team. They're going to get media hits out into the world, and those media hits are going to last forever, and those are going to help change the conversation and eventually propel animal rights forward in law. Possible. I'll show you now a table that we're using in the book. My colleague David Dana has done some of these media studies. This is one that looks at just 3 cases. We've done a number of others, but the media hits, so the news citations, and we could break this down further into favorable versus unfavorable, and it gets even more interesting. And I'll say nothing about that now, but it's not a flattering picture. But what this shows you is the citations to a case right after filing, and then the citations for I think we did 3 months after the highest court ruled against the animal rights advocates. And I don't want to overgeneralize about these numbers. I mean, in some ways you can see what you think of them. Let's not overread them. But there are a couple of cautionary tales here, potentially, right? The first is possibly iterative losing might face diminishing returns in terms of media interest. It's at least something that we haven't confronted, that I have not seen in the literature, and it's possible. Right? There are caveats even to that, at least on this limited table, because of course New York is a very different media market than Colorado, so maybe that accounts for much of this. But it's certainly a conversation that we should be thinking about in terms of resources and how we frame our message. The second thing I want to note, without making any normative judgments about value of cases, um, is that a lot of people that I encounter, and you all may disagree, thought that the PETA lawsuit about monkey selfies was less important, much less important than, say, a habeas petition on behalf of a wrongfully imprisoned animal. But you see here that it's possible, if you were to take that view, and I have not done any independent polling on that, but it's quite possible that the press impact or the press interest does not correlate with the animal rights stakes. That is to say, people might be more interested in the media, in the media might be more interested in stories that have less to do with animal rights if there's a sort of funny angle or a gimmick about it that they can tell jokes about. And this is true. Another way of looking at these is like if you're putting a monkey in a suit, is that good or bad for the animal rights cause, right? Not all press might be good. Now, I will say that I never thought winning would be easy, and so I don't want to again be too critical. It's quite possible that even if media hits go down as we lose sequentially in cases, it's quite possible that the impact on individuals goes up, or at least is very, very important. Perhaps when people learn about these losses, as I said, was a theory of marriage equality, they're going to be so outraged that they might become an activist, right? It's quite possible that they would be mobilized to our movement. And to test this hypothesis, my co-authors and I ran a number of studies. I'm not going to share most of them with you, but we found some interesting things. And the first here is this is an illustrative example of our findings. We took respondents. This is U.S., but a quite large N for this kind of study. And it's nationally representative in terms of politics, in terms of age, a very good sample. And we asked them a number of questions. The question I have up before you is whether they, on a 7-point scale, view it as morally problematic to confine animals for profit. You have a control group. And what we see here are statistically significant differences between everyone who learns about the true conditions of captivity for these elephants. They were all more likely than the control group in significant ways to think that confinement was problematic. But if you notice, condition 2 is we just provide that information to them. We say, hey, read this short squib about the confinement of these elephants. Condition 3 and condition 4 talk about litigation. So condition 3 is a lawsuit is filed, and that's the only additional fact. Condition 2 and condition 4 is the lawsuit was dismissed, but prior to an appeal. And so what we see is there's no difference between learning of the information about elephant captivity. People aren't more mobilized, more activated, more inclined towards animal rights if they learn about it through litigation, or they just happen to learn about it, say, through a billboard or through a commercial. Right? A second one that I'll quickly show you is this one has to do with the same question, but showing the impacts of a loss in a single jurisdiction. So here we have again a control. This time everything was identical except condition 2 is they received information from the zoo's website. So they received favorable information, or at least I think the zoo would characterize the way they describe their elephant enclosure as favorable. And then the fact of the captivity, just the facts. That's condition 3. Condition 4 is a personhood case. Litigation was filed. And then condition 5 is that case was filed and it lost in the Colorado Supreme Court. So we're able to compare how people reacted before and after a filing, and before and after learning about a loss. And we did this in sort of iterative studies. So I'm not going to go through all of those details. It would take the whole time. But again, the point I want to focus on here is that persons who learned about animal captivity were more likely to view it as morally problematic. Probably not a big earth-shaking conclusion to anyone who's listening. But the respondents who heard that there was a loss in the Colorado Supreme Court were not more favorably inclined towards an animal rights position than those who learned about the information just of a case being filed, just of trial court litigation, or just of learning of the information itself. So it's information that might matter and not necessarily the fact of litigation. So again, the point here, I don't want to overgeneralize, but that even when it comes to one of the landmark forms of animal rights advocacy through litigation in the US, there are a lot more questions than answers. And we can't be sure as an empirical matter that the movement will lose forward when we lose cases. It's not clear from the evidence we have. Again, one type of case, a very important type of case, but it's not clear that the losses add up to momentum in the minds of the humans. And you could take that as a good thing or a bad thing. I don't have strong views. I think that we would have to do further research on how do you get some of these things in the media? Like, is it more valuable to buy a full page ad in the New York Times? Like, there's different ways that you might get people talking. Litigation is certainly one of them, right? So I don't take this table or the table before it, or really anything we've found to say that animal rights litigation is a negative. But I take it as a cautionary tale before we conclude that every loss will meaningfully contribute to more favorable views for animal rights. It could be that that's the only way to get the information before the public. Okay, so if I don't have a great deal of optimism growing out of losses, and anyone who's litigated in the animal rights field knows we have a lot of losses, then where do I have the optimism that I wanted to talk about? Well, there's several sources, but one of the most important is, for me, the work that we've been doing in the clinic. So I talked a lot about empirical data. I want to pivot now to a little bit more qualitative or even anecdotal data for purposes of this presentation. And that is the defense of activists. I think that the defense of activists can be a really ripe area for advancing narratives and law that is favorable to animal rights. And I'll make just a couple points here. The first thing about these cases is that they offer the opposite of winning by losing. These are winnable cases, and we win by winning. The opposite theory of winning by losing is that the public loves a winner. There is a psychological phenomenon known as the bandwagon effect, right? And it's real. If you are winning, if you are chalking up wins, more and more people are going to be like, oh yeah, that's a winning team, and they're going to want to support you. And I will say that although I have seen and had conversation with animal rights lawyers who talk about the civil rights movement in the US as winning by losing, it's also the case that no less than Justice Ginsburg and others had very deliberate strategies of winning by winning over time. Very small incremental wins. What's the kind of win that will represent gender equality or desegregation in schools that threatens persons who are white the least, and that we can keep having a small win, and then we're going to move all the way down. Brown versus Board of Education did not come out of a vacuum, right? There have been lots of wins in higher education that were very, very carefully targeted for wins. And so I think that these defense cases are cases where you can win. I put one example up here. I'm not going to talk through all the facts just because of the time, but this is a case where the short version is that two cows escaped from a person who was raising them for meat, and it's like a movie script. These two cows actually wandered, apparently by chance, onto a cow sanctuary. I mean, you can't make that up, right? I mean, they really did. Nobody took them. They just wandered on to a sanctuary where this woman, Tracy Murphy, bless her, she devotes her life to caring for cows. And they showed up there. And so Tracy took care of these cows, treated them like children, as she does all the cows, fed them and the like, even talked to a lawyer. Lawyer told her her rights about, the cows and this kind of thing. I won't get into the details. But one of the interesting things that happened is that a person eventually showed up because she reported having found cows on her property, showed up and said, I need these cows. The person didn't have any proof of ownership of the cows. It just demanded them. It was pretty rude. It's all recorded. And Tracy said no. Well, it turns out that this person who showed up was himself a state trooper, and his brother-in-law is a supervisor in the state troopers of the New York State Police. They came back. They arrested Tracy Murphy, but they didn't just arrest her. They didn't just handcuff her. They put her in leg shackles like she was a terrorist, and they carted her off, and they've made her face charges for years in prison. And then they sort of said, well, if you plead guilty right now, as they hope that all animal activists will do, we can make this go away and you can just do some community service. And here's this woman who runs a sanctuary, and she said, no, I don't want to plead guilty. Right? She made that choice. And it actually still right now gives me chills to think about her having the courage to do that and face imprisonment. And she said no. And we litigated the case for her. And long story short, we won. And the reason that we won was animal centric, right? There is a way of representing people when you care about animals that is different than you would just represent a person. Tracy's biggest priority always was getting the cows back so they weren't slaughtered. She wanted the cows. She worried about the cows more than she worried about herself. I can tell you that normal defense lawyers would not have prioritized motions about preservation of cows from slaughter. They would have thought that she was, crazy or something. But we filed a lot of those things. And the lawyers in this case just consistently kept harassing the prosecutor. Where's the cow? Where's the cow? Where's the cows? And never to effect. Well, eventually we got the case dismissed because we argued that the prosecution had destroyed material evidence relating to the prosecution. Essentially, we're going to make the person who said they were his cows identify them through a lineup of cows or something like that. We could go into the silly details of the case, which are quite funny. But at the end of the day, it was the fact that the prosecution had kind of covered for this rancher and allowed him to slaughter cows in the dark of night that allowed Tracy Murphy to be acquitted. And lots of cases like this exist, right? There's a body of work that we are trying to build up with lawyers all across the country, and we're hoping to do more with some partners in the UK we've been talking to and in Canada. But these cases are winnable, and they allow us to tell stories. And that's the other point I want to make about this. Myself and a couple of others have written an article in the Harvard Law Review Forum about this theory of social change. And essentially, it posits that this is the best way to use law to tell a story. That it is so hard to stand up and give a lecture like I'm giving right now, or to tell students in your class, or go stand on the soapbox in public and say, the law gets it wrong when it comes to animals. It's a very hard case to make because everyone thinks that you already have, sort of the end in mind. But these cases to a person allow us to make that point, and the litigation does the talking. And what do I mean by that? We're able to say, just as Peter Singer and the Effective Altruists have shown us, there are wildly high numbers of animals that suffer to death on factory farms. Factory farms are unpopular everywhere in the world. The polling differs, but it's always very unpopular. And we're able to tell stories about animals that are going to die from disease, die from dehydration, die from starvation. In pig farms, by the way, that's about 20% of the animals in the US. It's about 15 to 20% by industry numbers. So 1 in 5 of those pigs is going to suffer to death before slaughter. And we tell the story of how the law allows that. It's not a crime. That's an industry practice. But the person who goes in and rescues one of those animals that is on the verge of dying imminently, they are the criminal, right? That is a powerful story, right? So when you think about ways that, A, you might get acquittals through juries, through jury nullification, through motions practice, but you might also just have one of the most compelling ways of telling the story about how the law fails animals in a systemic way that we can put forward. And I'll just tell you that journalists are quite interested in this narrative, right? I've had lots of activists in the US tell me that the media interest in investigations is gone, that undercover investigations are no longer newsworthy because it's sort of been saturated. They don't think it's new. That's not true when the investigation is one that is tied to a rescue, because then you have someone facing these criminal charges for saving an animal that everyone agrees was diseased, was going to die. Right? The other thing that I'll say about these cases, just very quickly, is that there is hard doctrinal animal law work happening here. And what do I mean by that? Within the next month, we're going to have 2 briefs filed that I could spend a whole presentation talking to you on what we are litigating in those cases, but they are different forms of personhood arguments. They are arguments about why rescuing animals is not only not a crime, but required by the common law, that this should be something we should reward, right? So to take one example, California has a necessity defense. It's an entirely common law created doctrine. It's not codified in statute. It is a common law evolving doctrine. And all we are doing in one of our cases is saying the common law, much like Steve Wise and the Non-Human Rights Project have done for decades, the common law must evolve. It is not static. It is not calcified. It is not fossilized. And so as it evolves, it's going to have to evolve to include the rescue, not just of humans, but also of animals. And here you can think about how much easier this litigation posture is to argue that. right? You're arguing that a person should not be convicted and sent to jail, as opposed to this zoo should be shut down, or we should be able to take this animal from a zoo that's litigating hard in the other direction. We are going against prosecutors who say, no, 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 no. Animals are not persons. Animals cannot be rescued, that sort of thing. And so, I don't want to understate what is obvious, and everyone has probably had that thought already, which is that this kind of litigation requires an individual to put their own liberty at stake, right? And that's not something that we should take lightly. But when people are doing that, it's very powerful and quite possible that we're able to take up those cases and litigate on their behalf for animals. And I think it's explicitly animal rights litigation, and it would be a big mistake to not count it within the rubric of animal rights work. I'll also just say that another thing, and the last thing I'll flag about this type of work that I really like about it, is that it tends to link lawyers and academics with on-the-ground grassroots activists in the movement in a way that I think in our field, there's been a bifurcation that has always made me a little bit uncomfortable when I think about social change in general. Ted Hamilton, who some of you in the US may have heard of, but he founded a climate defense project here. In one of his books, I think his only book, he wrote that when it comes to climate change, the law is too important to leave to the lawyers. And that's how I think of animal rights as well, that we can't just leave it to the lawyers to come up with clever and creative ideas and causes of action. We're going to need more than that. We're going to need the creativity and the youth and the energy. And this type of litigation is able, at least in part, to harness some of that, right? So then the last thing that I want to do, and I'm trying hard to stay somewhat on time. I started with empirical data about winning by losing, and maybe it was a mixed bag or not entirely optimistic. I feel a great deal of optimism in some of these defense cases, although, even that we're going to have to eventually pivot. The government will change and the media interest will change over time, but I think it's a powerful vehicle right now. The next one I want to shift to is some more empirical data, and it relates to the sort of presumed dichotomy or bifurcation between animal rights and welfare. When I came into the field, there was this clear bifurcation. On the one hand, personified by Gary Francione, pictured here speaking at the Animal Rights Conference, who said things that were quite provocative, but he really means them, right? And he came out opposed to things like bans on battery cages, bans on gestation cages. And so on the one hand, that I think that to the outside observer, that looks like, oh my gosh, the animal movement is so crazy, they don't even want bigger cages. But on the other hand, Gary has posited a set of theories that seem quite reasonable, right? And I think that many of us in our own work have probably been critiqued as being overly incremental. Roberto Unger and others have written about the problems of incrementalism. So Francione has come out and said, look, legislation or regulations that are aimed at creating animal welfare protections, he says that is, quote, the difference between horrible and slightly less horrible conditions, right? So it's not much different. You're still using them. You're still killing them. He has called it, as I put on the slide, quote, happy exploitation. Right? There is no such thing as a happy cow being used for milk or a happy cow being used for meat. It's happy exploitation. This is a myth. And more importantly, for my purposes and for my study, he has said that incremental progress is not progress at all, and instead, quote, these are not baby steps, they are big steps in a seriously backward direction, end quote, right? So that's actually counterproductive to our cause. And he goes on to say, those seeking to promote animal welfare by regulating their treatment are doing more harm than they are doing good for animals. So this could be a source of tremendous pessimism because at least in the laws and reforms that I have seen as of late, it tends to be that we are seeing there's some progress, of course, in rights of nature and other things. But for the most part, the victories have been large welfare reforms, this kind of thing. And so what should we make of that? Well, my co-authors and I have designed a set of studies, and I won't talk through all of them, but we are, in fact, still putting together tables for some of them, so some of them are preliminary. But but one that I can share some data with, is a study that was designed to test the skeptical opinion that eating animals does not materially change, or people's views about eating animals does not materially change for the better following the enactment of a robust animal welfare protection, right? Francione's basic position is if you think that there's strong animal welfare laws, you might be a kind person and think it's okay to eat those eggs or eat those animals or whatever. And we did this, one of the studies, using Prop 12 from California, which you might remember is the law that targeted gestation crates and battery cage sales of animal products using the most intensive confinement. And one of the reasons we used that is that animal rights groups actually opposed it in the US, right? So PETA at the time said that this law would move us backwards because it will, quote, mislead consumers into thinking that it's humane to purchase animal products. And another group in the US, Friends of Animals, said, quote, this initiative should be fiercely opposed by everyone who cares about farm animal suffering, end quote. This is not just a high-profile instance of animal welfare law, went all the way to the U.S. Supreme Court, but also one that really drew the battle lines because groups didn't just in theory, but in practice opposed it. So Prop 12, what did it do? I'm not going to talk you through all the things, but basically, as I said, it eliminated the most intensive forms of confinement and the sale of products from that confinement. And so what did we do? Well, we created a couple of frames for study. The first frame was a confinement frame where we just told people, and it may have been the first time they learned it. In fact, many people admitted that, what gestation crates were for pigs, how they were, how they would spend their day, how much movement is allowed, that kind of thing. The second frame was a frame where we told people that the exact same information, this is how a gestation crate works, but then we added to that your state has banned it through a ballot initiative. And so you can no longer do this. And the worst forms of confinement are not allowed. And we added some quotes from animal protection groups that said things like, this is the world's most protective law in terms of factory farming, or this is the biggest limit on factory farming in the world, these kind of things. And then we compared these two groups. And our findings are pretty striking, and I think unsettle the long-standing Francione thesis at least a little bit. Among our study participants, again, a pretty large group of persons who are nationally representative, we found that persons who learned that their state was providing robust animal welfare protections through law were more, not less, likely to perceive eating meat, eating pigs in particular, as unethical. There was a moral shift among persons who learned about welfare laws in their jurisdiction that benefited animals. So bigger cages didn't lead to more acceptance of eating animals. Rather, it had the opposite effect. And let me give you the real punchline in terms of numbers. After controlling for relevant variables, and I don't have the list in front of me, but we controlled for education for sure, we controlled for income for sure, we controlled for age for sure. I think we controlled for politics on this. But after controlling for a number of relevant variables through a logistic regression analysis, we find that the odds of viewing eating pigs unethical is 2.13 times greater if the person learned about a state law banning the use of gestation crates, right? So you are more than twice as likely to be skeptical about eating pigs if you learned that your jurisdiction, excuse me, had one of the most profoundly protective animal welfare laws in the world. This is directly at odds with everything that we had come to imagine or been told about how animal welfare laws work. Now, of course, I don't want to overgeneralize this either, right? It doesn't mean that suddenly those people are going to go start marching with animal rights protesters. It doesn't mean that that all incremental reforms are equally good, just as, we don't always win by losing. But I think it does challenge the accepted wisdom among many people who I work with and respect very much that, quote from Francione, welfarist laws simply facilitate the indefinite perpetuation of exploitation, end quote. Our research suggests at least the possibility that the arc of moral concerns for animals may actually increase when persons are informed about attempts to mitigate some of the most egregious forms of animal suffering, right? So my position at this moment is probably that is a point of pretty great optimism for us, because if animal welfare laws are conceivably winnable in the short term, and animal welfare laws can lead to greater skepticism of eating animals, or perhaps greater support for animal rights, then animal welfare might be a pathway towards a thick rights position. And this is a great place to end, right? I think that when you study animal rights or you work in animal rights law, it's only natural to become disappointed, almost disillusioned. And I have always had nothing but puzzlement for the Winston Churchill quote that he says something like, "For I myself am an optimist because I can't think of any use of anything else," or something like that. Doesn't seem to be much use of anything else. It's always puzzling to me, because if you're pessimistic, then every surprise is good. But I'm always looking for slivers of optimism, glimmers of hope, in a world that still stubbornly believes that animals are ours to use and to eat. And I'm not sure that I've found it all the way, but I do think that even if sometimes losses can embolden our enemies, and sometimes losses don't lead to wins, there's reason for optimism through the spirit and the hope and the efforts of activists around the world that I've been seeing rescuing animals, and through the defense of them in law. And in particular, I think that we should give more thought to breaking down this supposed wall between welfare and thick rights. And I hope that the research that Janice and David and I have been doing will be the first step in that direction. So thank you so much.